having improved like never before. And we are all saying that CapEx cycle is once again picking up. I think this is one activity, and we can see the smile on the face of Harish ji. So, and actually the smile should be there on every professional's face, because this is the time of the new India. The India where we first saw the development of services sector. Now the experts are seeing a new growth trajectory for manufacturing sector. So from that perspective, I think today's seminar, today's session, with the experience of Harish ji coming to us, would be a very, very important and interesting subject to understand the nuances of fundraising. So I welcome all of you to today's seminar. I welcome Harish ji for accepting our invitation and taking out time for this program. And before giving it back to Kiran ji, I would like to tell briefly about Bharatiya Vitta Salakar Samiti. This is a body of different professionals from all across the spectrum, be it chartered accountants, company secretaries, so lawyers, CWAs. So it's basically a cross amalgam of several professionals coming together, and with a very important purpose of linking professionals' capabilities with the aspect of nation building, culture building, and making India even more relevant, more important, and more, for that purpose, more powerful. And in that process, it ensures the development of all who are associated with us. So I think with this brief background, where at BVSS we keep on doing, apart from these knowledge sessions, we do sessions where we talk about India, we talk about culture of India, the educational heritage of India, how we can make it again in the same powerful where we used to have 24 to 25% world GDP share. And then talking with the government, telling them what are the ground realities, what are the problems, what are the solutions to those problems. So this is all what BVSS does. In short, we call us a think tank of finance and accounts professionals. So I once again welcome all the participants who have gathered together for this all important session, which is today, and we look forward to hearing from Mr. Harish ji. Thank you.
Thank you, Puneet ji. Thank you so much. So to deliberate on this important topic today, we have with us Mr. Harish Kumar. Mr. Harish is a partner with LLN Partners, formerly in Luthra and Luthra Law Offices, with over 18 years of diversified experience in dealing with corporate legal issues and enabling solutions and implementation of business and clients. His expertise spans a wide range of corporate and legal matters, including corporate restructuring, mergers and acquisitions, joint venture, corporate disputes, and wide advisories to best government practices. Mr. Harish has extensively dealt with various ministries and Department of Government of India, MCA, SEBI, RBI. His advisory role also extends to various advisory given to Government of India and key industrial associations like CII, FICCI, SOCHM on various industrial concerns and legal issues. Mr. Harish has also been a regular speaker at various professional programs, workshops conducted by professional and government bodies. Mr. Harish is a company secretary. He has done his law from University of Delhi. He's an insolvency professional, and he also has various memberships, including the membership of Bar Council of India, Delhi High Court Bar Association, member Delhi chapter of Chambers of Tax Consultants, PhD Chambers of Commerce, and Committee on Company Law and Governance. So on this, with this rich experience, I request Mr. Harish ji to please deliberate on this topic.
Thank you very much, Kiran, and thank you very much, Puneet ji, and the whole team of BVS for this kind invite. Actually, first time, look forward to be a kind of participant of similar, or even I would say better sort of seminars going ahead. Would be my pleasure being here. And I think I echo the sentiments of Mr. Puneet Agarwal. He cited about now we have been seeing some healthiest balance sheet, and you guys would appreciate that we we have at least dreamed about of becoming a 5 trillion economy in time to come, and how the economy would grow. Amongst all other factors, my personal belief is that it's a kind of, inflow of FDI in terms of the M&A that is going to be kind of, playing a key role in achieving this dream of 5 trillion economy. And I have seen a lot of development, I would say, in a positive sense when you talk about the progress, development, or sort of amendment in the core area dealing with or to facilitate the M&A activities, be it a kind of reduction of the corporate tax to 22% from 30%, for the existing companies, which happened about year back, be it sort of, rollback of surcharge on the foreign domestic portfolio, investor, be it like sort of, relaxations under FDI for key sectors such as the, corporate contract manufacturing, single brand, retail trading, insurance intermediary, and digital media, and be it like, allowing Indian company, which nowadays are a grown-up startup with sort of, differential voting right, to go and undertake IPO. Recently, we have also allowed sort of Indian companies to get a direct listing on overseas sort of, sort of foreign exchanges or permitted jurisdictions. So see, same way, we have also sort of given exemptions to the startup which are registered with the government of India and their investors from the angel tax, which has been sort of a matter of concern to the angel investor in the startup, sort of organizations. So the idea is that, unless and until we work into that direction and make the relevant amendment with that focused approach, probably we may not be in a position to touch upon this, Puniji, you are saying something? Are you on mute? Okay. I could see that you are speaking something. So, okay, no worry. So, my sense is that, if you work sort of, with that focused approach, given these kind of focused amendment, these kind of relevant amendment taking place, certainly we are in a position to achieve this 5 trillion economy, sort of dream of 5 trillion economy. Now, today, I understand my topic is basically to discuss, deliberate upon the relevant aspect of fundraising processes. And I understand, this audience, which is comprising about 40 to 45 persons, comprising of different professional of different sort of, experience, maybe in-house, external, company secretary, chartered accountant, and lawyers. So my idea is to do a kind of interplay between the relevant provisions, be it the company law, be it the FEMA, be it the relevant governance issue. That's the whole idea I'm going to do. And I'm going to sort of, what I'm going to discuss, sort of key challenges, practical areas of concern, and potential solution, which probably I may consider to be an appropriate one within the legal sort of permitted, provisions. I really, whenever I speak, I really want to make it more kind of interactive, to be very honest. It has to be two-side sort of conversation, but yes, we are doing this sort of, online session, and this has sort of its own inherent limitation. So from my side, it's an open, kind of platform. I request anyone, maybe through Kiran, they may raise their relevant concern, query, anytime while speaking on any topic which I'm going to touch upon, or maybe alternatively, once the session is over, I'm always available to entertain those FAQs. So with this, I think, let me give my thought, on those relevant aspect of provisions, including the relevant regulatory framework, which may have a bearing, in relation to the fundraising processes by a company. So, as I said, the objective here is to discuss, deliberate upon the key aspect pertaining to fundraising processes. So fundraising processes, if you think about a fundraising process by any company, so what could be the broad ideal steps when any company of any size, be it a early stage startup, or maybe it is a kind of big conglomerate, something like that, Reliance Industries, highest, the biggest Indian private sector company, or maybe a day one early setup startup, what could be the broad steps or actions involved? So every fundraising will have to necessarily undergo, these five or six stages. So the number one would be basically, identification of the relevant investor stroke target. So when I'm saying investor, means from a issuer perspective, from the target, the company seeking fund, they have to identify the relevant investor. And from the investor perspective, who has a money to invest, they have to basically identify the relevant target entity in which they want to sort of invest, in the amount, size of the investment, the requirement of the target entity, the which sector company they are in, and the kind of prosperity of this sector may have in the next 3 to 5 years to go. So once we have got the identified target or the investor, we have to enter into some document. Either we call it as a term sheet, or we may call it a kind of a memorandum of understanding, MOU. So generally these document, be it MOU or term sheet, these are generally non-binding in nature, except certain clauses which are binding in nature. For example, during the course of discussion on this fundraising, you will not go anywhere as a target company to seek fund from separate, additional investor. Same way, I will not go and do a kind of window shopping around. Same way, there are some confidential information which we will be sharing pursuant to this term sheet or MOU. You will not be sharing with the third party, so am I. And there is a dispute resolution clause. So there are certain clauses which are binding, otherwise term sheet remains non-binding. So once we have sort of enter into a term sheet which captures the broad terms and conditions of the transactions, fundraising, and the relevant aspect, we as an investor always conduct a kind of due diligence. So due diligence basically is a concept, or I was a principle which again nothing but reiterating the aspect, the very famous saying that let the buyer beware. So as you are going to do a kind of investment into a target, you have to make the possible feasible assessment about that company in terms of the potential risk, because tomorrow something goes wrong with the operation of the company, you should not blame anyone. You are a corporate sort of citizen, you are a corporate investor, you are expected to do this sort of minimum sort of task at your end, before making this investment into the target entity. So identification of the investor or the target, entering into a term sheet, third is a diligence. And yes, once the diligence is done, we have to enter into a definitive agreement, including negotiation. So let's say we as a company are issuing shares to an investor, which is a fresh issuance of shares. We have to enter into the necessary share subscription agreement. Same way, if there is a kind of share subscription, at the same time some secondary purchase, in addition to share subscription agreement, there can be a share purchase agreement. When we draft this document, share purchase agreement, share subscription agreement, it includes some sort of detailed sort of provisions regarding various aspects about whose duty is what, whose rights are what are going to be the right, obligation, interest in the parties, what are the representations, warranties of the company, promoter, what are going to be the consequences in terms of failure, in terms of liability, what is the indemnity amount, and what are the limitation to indemnity. So these all are the relevant clauses which we have to detail within these definitive agreement. So once we have entered into the definitive agreement and done the negotiation part, we do the completion of the transaction. We call typically it as a closing. But prior to closing, there may be some sort of conditions, some sort of relevant aspect which would need to be satisfied by the company or the promoter or the investor. We call it a condition precedent, CP. So this is basically a range of general sort of actions, steps, sort of stages of any fundraising process. As I said, see, if we start discussing these documentation aspect probably, and that's something which I was discussing with Kiran also, that discussing the each and every, in fact, the relevant aspect of this documentation probably would itself take class of about 4 hours. Right? That becomes so critical in terms of drafting of any SSA, SPA, SHA, term sheet, MOU. So that requires a lot of sort of commercial and legal aspect to be discussed, deliberated. But I thought it would be appropriate if I give you a kind of bird's eye view about those documentation stages which get involved in any sort of fundraising process by any company. Now, coming to the let's say relevant aspect, primarily I think when we talk about the fundraising, see, if you are a company other than a listed company, it would be the Companies Act, which has a significant role to play. If you are a company which is also listed, in addition to the Companies Act, you have to take care of the SEBI related provisions. If you are a company irrespective whether listed or unlisted, but you are making issuance of shares or raising fund from person other than resident, means a non-resident, you have to take care of the relevant provisions of FEMA along with the FDI policy. So generally, Companies Act, SEBI, and FEMA regulations have a role to play together. Invariably, I would say the Companies Act, 2013, which has just completed about 8 years of its existence, having been notified on 12th of September 2013, has the significant role to play in terms of fundraising process by any company of any size. Because a company, be it listed, unlisted, private, public, has to comply with the provisions of Companies Act. And let me share with you one of the, probably maybe you guys must be aware about it, but when the new Companies Act came into existence, it sort of got notified with the highest possible governance related provisions, embodied. And I at times feels that, company law 2013 somehow gone sort of overboard, because it was even excessive in nature. What actually happened, SEBI law used to be more stringent than that of the Companies Act 56 Act. But with this new company law coming into effect, even SEBI law got amended. Basis the new concept, new definitions, new requirement brought in under the new Companies Act 2013. And let me share with you, I think a realistic figure. There is a press release also. I think it was issued somewhere on 13th December 2015 by SEBI. And if you can go and see on the SEBI website, there is a press release which is of 23rd of December 2015. What they have done, SEBI issued a list of about 221 companies. SEBI issued that list of about 221 companies, mentioning that these companies, and by the way, none of that company was a listed company. They all were unlisted public companies. They were saying that these are the companies which are in default of the relevant provisions of the Companies Act, vis-a-vis raising of funds by way of shares, equity share, preference shares, convertible, non-convertible debentures, primarily non-compliance of section 42, 62, 71, and relevant provisions of the Companies Act. And why SEBI has a role to play there? Because under the Companies Act, we have a section 24. If you see section 24 of the Companies Act, which basically is a corresponding section of section 55A of the 56 Act, that section gives power to SEBI to even administer and adjudicate the offenses or non-compliances by an unlisted company. So that section says that if there is any aspect which deals with the issuance or transfer of securities by a company which ought to be listed, which is not a listed company, but which should be listed, which is about to get listed. So those aspects, those non-compliances should be administered and adjudicated by the SEBI office only. So primarily what happened, let's say many companies which were unlisted company, they would have done some issuance of securities to person, let's say more than 200 permitted number for the IPO, or maybe they would have done some other non-compliance of section 4262, which would have led this matter to be adjudicated by SEBI officials pursuant to section 24. And that's how and why I always mention that section 24, which used to be section 55A of the 56 Act, and that section in fact was originally inserted by the Companies Amendment Act 2000, effective from 13 December 2000. So that section has been the most powerful yet ignorant section. That's my saying about that section 24. This is the most significant section under chapter 3 and 4 of the Companies Act, but at the same time, this is most ignored section by many people, including professionals, including the promoters or the company's officials. But yes, this section itself took the day of light, when the SEBI came out with that sort of press release. And you would have heard about Sahara matter, what happened with Sahara. Sahara 2 companies which would have raised the amount of capital via issuance of optionally fully convertible debentures, and there was to and from with the SEBI. Eventually, SEBI concluded saying that the Sahara was in contraventions, via issuance of this OFCD, wherein they issued these shares to about million of persons and raised about 50,000 crore of money. Eventually, that money got refunded back to the investor with amount of 8% interest. So that list of 221 entities is actually topped by Sahara entities. Those two entities. If you see that list of companies. So that's the important aspect of section 24, which I thought I should share with you. Now, one more important aspect, I think it's purely a question of law, but I think it has a significant practical implementation. And I always mention about this thing. See, as I said, the Companies Act 2013 is the most important legislation when you talk about fundraising process by any company of any size. The most significant feature of the 2013 Act, Companies Act, is that rule making power by the central government. And let me share with you guys, why I'm telling you, because this becomes very, very important for you. Under the 56 Act, this power of making rule, we call it a subordinate legislation, wherein the central government is empowered to make relevant rules, regulations for the purpose of carrying out the objective of the law. The percentage of that rule making power used to be about 16%, 16%, meaning thereby out of the then total 658 number of sections under the 56 Act, it was about 108 number of sections which was giving that rule making power to the central government. So out of 658 number of sections, only 108 number of sections, which constitutes about 16% of total act, was giving a rule making power to the central government. But now this percentage of 16% has gone up to 76%. Under the new Companies Act, out of the 470 number of sections, it's 346 number of sections, which constitute about 76%, which gives this rule-making power to the government of India. Now, why it is so relevant? I tell you what happens, when you interpret when you are sort of doing an analysis or interpretation of the relevant provisions dealing with a particular situation, you have to read the law, which is the relevant section, along with the relevant rule. At times, you will feel, probably, you may confront with a situation that something which has been codified under the relevant rule, which is a subordinate legislation, may have gone ultra virus, may have been, drafted in an excessive manner, which has gone beyond the permitted limit of the primary section. So in that situation, I think you would be legally, correct to take a view which would limit the application of that secondary rules within the ambit of primary section, and that becomes very, very relevant for you. And we have seen some sort of, a good example instances in past, wherein we have found some, amount of excessive delegation under the relevant rule. And obviously, basis of follow of representation before the ministry has actually rectified, those sort of rules, and they have brought it within the ambit of the relevant section. And what happens, we have to take a legal position at that time, because eventually, let's say there's a lacuna in drafting, or for whatever reason the relevant rule would have ignored the implication of the primary section. But if you can take that view, which is legally correct, probably that may save you. I will give you a live example. There have been so many examples. Let's say let me give you an example of CSR. See, I'm going moving from this topic, but just to give you a kind of example how this may be of help to you. Let's say when the CSR section 135 got notified, CSR puts an obligation on every company which is subject to relevant threshold of net worth, turnover, or profit, right? So it is a company which is subject to relevant threshold has to make contribution towards CSR. So the obligation under section 135 was on a company, right? And the company term was defined under the Companies Act. Company means a company which is formulated, incorporated, registered under the Companies Act 13 or any previous company law. Company, the term company, which is a defined term, does not include a foreign company. Foreign company may be regarded as a body corporate, but foreign company is not a company. If foreign company is not a company, then foreign company will never be subject to section 135 subsection 1, which talks about CSR obligation on a company. And that was an issue which was firstly brought to my notice for a legal positioning. And obviously, given the situation we were at that time under section 135 subsection 1, section says company, but when we got the draft rules, foreign company rules, CSR rules, that rule even brought within the ambit of section 135 a branch of foreign company, which has got established in India. So branch office is a foreign company, not a company, but that was put subject to CSR obligation. So it was a lacuna in drafting. And we obviously this was brought before the ministry, and you would have seen that the company that got amended, wherein they have brought in a relevant amendment within the relevant chapter dealing with foreign company, I think section 387, and they have provided an explanation by way of amendment saying that the relevant provisions of CSR would apply to a foreign company mutatis mutandis, as if the foreign company is a company. So we have some instances, so idea was to bring it to your knowledge. When you do any interpretation of provisions, you have to read in totality. You have to read that rule. Maybe you are reading the provisions dealing with the private placement of security. You are reading the provisions dealing with the private preferential issue of security. So read that rules in light of the kind of overall scheme of the act. Importantly, the prime section under which that rule got drafted. So if you get confronted with a situation wherein there is some amount of inconsistency, probably you may be right in taking a legal position wherein the relevant portion of the rule, which appears to be excessive or ultra vires, may be disregarded. So that's the way I think, and that has been done on some instances. Fortunately, good part is that government has already made 2-3 times of amendment to the Companies Act, and also rules got notified. But that has become a kind of area of concern also during the course of implementation of the new Companies Act 13. But now, yes, to a large extent, I would say the act has taken a shape of its own interpretations. But yes, there's always a kind of I would say area to further get evolved, in due course of time. Now, coming to some relevant, I would say, term which would be of probably interest and use to you, when you go do a fundraising activity. See, there is a term called associate company, and I will pick only 3-4 relevant terms because I think these terms become very relevant at some time. I feel that we go into more legal documentation, discussion, negotiation, but we disregard the practical aspect of those terms, which may have a significant bearing in time to come. But these terms become relevant going forward. Even I would say post raising of the funds by the company. So there is a term called associate company. Associate company, if you see the definition under Companies Act, I think section 2 subsection 6 of the Companies Act. So associate company primarily means in relation to a company, the other company would be an associate primarily when the first mentioned company has some sort of significant influence, I can mention. So meaning thereby company B would be an associate of company A if company A would have significant influence in company B, given the fact that company B is not a subsidiary of company A, but still company A has some significant influence. And significant influence generally defined to have a 20% voting power. Or maybe I have a control, of the business decisions, of company B. So irrespective of control of the business sort of, operations, business decisions of company B, if company A has 20% of the total voting power of company B, then company B would be an associate of company A. Now I tell you why this is so relevant. See, you guys, as I said in the beginning, and this is my understanding, you guys are either the practicing professional advising to your client or the investor, or you guys would be acting as in-house counsel in a company or maybe an investor. So who is going to make investment? See, when your client is making investment, when an investor is making investment into the shares of company B, and nowadays we have got a hybrid instrument, which is most preferred way of investment. Generally CCPS, compulsory convertible preference shares, or OCPS, optionally convertible preference shares. Nowadays, 80% of transactions are being done through using CCPS, preference shares, rather than equity. Because we want some sort of assurity in terms of return. We want some sort of, assessment of risk also. We don't know about the prospect of this company for next 2 years. Maybe there may be some risk attached to see we can work company for next 3-5 years, only then we'll get it converted. If the valuations are high, then only we'll get it converted. At the same time, we'll keep getting some sort of minimum assured return by way of sort of dividend. So let's do by way of a preferential safest route. At the same time, we will get some sort of rights, some sort of control in the company by way of affirmation voting right. And that's how and why preference shares, be it convertible compulsory or be it convertible optionally, are generally, I would say, preferred route of investment, about 17-80%. Now, what typically happens, I don't know if you guys would have realized, but I have been always noticing that point. There is a tendency, on the part of the investor, and I don't know whether or not it is a thought through one. They put a clause within the definitive agreement. Let's say in this share subscription agreement, they say that I am investing into your preference shares, which are convertible. So my holding, I would have, let's say your company have about 100 crores of equity share capital, but I'm investing about, let's say, 60 crores of preference shares, which are compulsory or optional convertible. But I will assume my voting in your company as if conversion basis. As you know that preference shares generally don't carry voting right. They do not have a right to vote. Generally, they have no voting right. And that's how they are preferred class. They'll get your, dividend at a predetermined rate. And in case of capital repayment, you will get your capital repaid first. But you will not have a right to vote on matters which are put before the equity shareholder, who are the true owners who carry the risk. But what we put in the agreement, I have been seeing that preference shareholder putting it that I will have a voting right as if conversion basis. So I will assume that my preference shares have been converted, and basis whatever is the percentage I get in the equity, I have a voting right. So as in my example, I said you have 100 crores of equity share capital, and the investor would have put 60 crores of preference share capital, which is convertible, let's say 1:1. So probably post conversion, he would have got, let's say, about 40% of total voting power. The moment you put that saying that 40% voting power, that target company has become a associate company of your investor. And if that voting percentage is more than 50%, that would become a subsidiary company. The immediate implication of this is that the requirement of section 129, which says that have to do accounts of required to be consolidated as per the applicable accounting standard read with section 129. So the moment you put CCPS, with that clause of as voting as if conversion basis, that target would become a consolidation, and it may not be again, a preferred choice of the investor to do this consolidation, because consolidation requires many other factors along with the monetary financial. It requires some non-financial detail also, and people may not be kind of comfortable with those sort of what you call consolidation. At the same time, when you do the investment and you get some excessive rights, we call it generally affirmating voting right. You say that your target company cannot do this thing except with my approval. Your target company cannot borrow money except with my approval. Your target company cannot do any related party transactions except with my approval. Your target company cannot do appointment of any of its KMP except with my approval. Your target company cannot enter into any material contract except with my approval. So what you are doing? You are seeking control on the business operation of the company. By virtue of the definition of section of control defined under section 2 subsection 27, this preference shareholder would be construed to have got a control in the company. And the immediate implication of control is there under section 2 subsection 69. We call it a definition of promoter. The moment you acquire control, you have stepped into the shoe of being regarded as promoter of that company, in which you would have invested basis your general, a business acumen, saying that we are here to invest for next 2 to 3 years, maximum 5 years. After 5 years, we'll get the decent return, get an exit from the company, either by way of an IPO or otherwise secondary sale. But we never intended to be regarded as a promoter, because the moment you qualify to be in control, you are a promoter, and your details are required to be given in the company's annual return. And there are certain obligations cast on the person having control, or the person who are regarded as a promoter. So that may be basically an unintended consequences of your language, which you would have basically put within the subsidiary. Yeah, I could see some message, some pop-up. I saw a chat which says that please further clarify this point.
We have asked that person to further explain the point. Actually, we don't know which point he's asking to clarify more.
No, no worry, no worry. As I said, anyone can raise any concern.
Correct.
But
Anyone has any concern, please give us a question in chat box, complete question.
yeah, so again, as I said, so how to get out of the ambit of this controller promotership? There is always a thin but critical line of drafting of an agreement. When I put in the first example that if you put something in your agreement saying you can't do this, that without my approval, it's a blanket sort of, it's a complete no from our side. You can't do this thing except my approval. It's a person appears to be in control. The logical way of drafting it with a view to get out of the ambit of control is that put some sort of reasonable logical threshold. For example, rather than saying that you can't do any related party transactions without our approval, say something like this: you cannot enter into a related party transactions for amount exceeding 10% of your turnover, 5% of your net worth, 20% of your whatever threshold. You cannot make a borrowing of funds for more than your net worth. You cannot appoint the functional head, or you cannot appoint the CEO, CFO, some positions of respectable, responsibilities, accountability. So put some threshold, because we call that if there are some threshold, these may be regarded, and there have been cases, plethora of cases, decided by the courts, SEBI, SET, competition law. If you put those qualification, those threshold, these are regarded as, I would say, monetary protection, rights or protections for minority shareholder, rather than rights to step into the sort of shoe of promotership or control. So make it as if these are the monetary protection instead of being regarded as a rights, which are giving you a control. So that's the relevant factor which probably you have to consider while drafting those provisions. So that's how associate company and control are relevant point. I thought to bring it to your kind of knowledge. Now debenture is again a very relevant term. Debenture definition has got amended twice or thrice during the course of implementation and further revision of the Companies Act. So debenture, it could be secured debentures, it could be unsecured debentures, it could be convertible debentures, compulsory convertible debentures, optionally convertible debentures, it could be listed unsecured debentures, it could be unlisted unsecured debentures. So debenture may be different kinds, actually, different types rather, And one of the important aspect of debenture is the stamp duty. Stamp duty payment nowadays has become a a considerable point for any transaction of fundraising. So stamp duty implications of debenture depends actually which class of debenture is this. If it's a debenture which is non-marketable, it would fall under different category. And maybe article number 19 of the relevant stamp act. But if it is a debenture which basically is kind of a marketable security, it would fall under different class, under different article. Let's say article 27. If it is a debenture which is secured by way of mortgage, it would fall under different article, article 29. That too subject to some sort of exemptions. If it is a debenture which is basically purely in the nature of unsecured debenture, it may fall under different article, maybe article number 5 dealing with the agreement. So that's how I'm saying debentures, it's a typical way of its typical class would decide the incidence of stamp duty. That's how it becomes very relevant for you to opt for the right sort of form of instrument vis-a-vis debentures. One of the relevant aspect also which you have to mindful about debenture is that debenture has a kind of a significant role to play vis-a-vis deposit rules. If you read deposit rules under the Companies Act, deposit says that deposit generally means money or anything which is money's worth. If a company would have received any money, or money's worth, this typically is a deposit, except we have a list of about 18, 19 category, 18, 19 transactions which are excluded, from the ambit of debentures. So deposit meaning is inclusive, but deposit exceptions are exhaustive. So if anything is falling within the list of 18, 19, they are non-deposit. Otherwise, everything is deemed to be deposit. And under that, I think item number 9, which talks about debenture, is a classic example of deposit or non-deposit. And again, that item number 9 has got amended twice, I believe, under deposit rules. So what they exclude, they say that if your debentures are compulsory convertible within 10 years, then it is, a non-deposit. Or if your debentures are, let's say, unsecured but listed debentures, then again they are non-deposit. So meaning thereby, if your debentures are convertible after 10 years, or your debentures are unsecured but unlisted, then they would fall within the ambit of the term called deposit. And given the sort of regulatory framework around deposit, I don't think any of the company would be willing to, take any instrument or any money by way of an instrument like debenture, which would get covered by the term deposit. Reason being that, deposit is a subject nowadays which which no one company would like to kind of touch upon because of the draconian, panel provisions we have under section 76, 76A of the Companies Act. In fact, as a matter of record, let me share with you guys, from the commencement of the Companies Act, none of the company has, I think, which used to receive deposit under the 56 Act. These companies have stopped taking deposit because, number one, the amount of deposit under the deposit you can take is a restricted amount. You can't do beyond that. At the same time, you have to do rigorous compliances. But if there is a lapse in the compliance reporting, filing, disclosure, then there is a serious disproportionate amount of, penalty for a good reason. And that's the reason deposit, raising money by way of deposit has not been a kind of preferred way of, sort of uh, uh, it's not a preferred kind of option for the company to raise money via deposit nowadays. So that's how deposit raising of fund via debentures has to have a sort of relevant, kind of analysis in the context of stamp duty, relevant rules, and deposit. Okay, when we talk about the relevant rules, see, again, I'm not going into the procedural aspect. Happy to entertain any query. Primarily, there are section 42, section 62, section 71 of the Companies Act. Section 42, you have to comply with vis-a-vis the private placement of securities, and securities include debentures. Section 62, you have to comply with vis-a-vis issuance of securities, including convertible securities. So if debentures are convertible, let's say optionally or compulsory convertible, you have to comply with section 62 additionally. But if debentures are non-convertible, strictly a debt, non-convertible, then section 62 has no role to play, because section 62 applies only to the shares and convertible instrument. Section 71 of the Companies Act would have to be applied with in case of debentures which are secured in nature. If debentures are not secured, then section 71 and relevant rule, which is rule number 18 under share capital, rules have no role to play. And obviously, if the company is a listed company, you have to comply with the SEBI LODR, SEBI ICDR regulations. Needless to mention, I said in the beginning that in case of involvement of any foreign investor, you have to do the relevant compliance of FEMA, primarily non-debt instrument rules here. CCDs are generally classified as FDI. It's an equity instrument for the purpose of foreign direct investment. But if it is optionally convertible, then it is considered as ECB for the purpose of FEMA regulations. Now, typically, how a company can raise fund, for the purpose of for the purpose of our understanding, let's classify the company into two parts. One is a private company, second is a public company. So, private company can do, a fundraise by way of a right issue. Private company can do a fundraise by way of, a private placement / I would say preferential issue. But if it is a public company, in addition to these two route, right issue and the private placement, they can also do, IPO, public offering. And people also say, sir, bonus issue is also a kind of, issuance. I say, yes, bonus issues is a class of a kind of issuance, 100%, which is permitted under section 63, I believe. But bonus issue is nothing but a conversion of your one account into another account. You do capitalization of a free reserves. So you have an entry as free reserves which get converted into share capital. You don't get any money. In turn, company does not get any money out of bonus issue. It is only right issue or preferential issue slash preference private placement. You get money. Otherwise, bonus issue is not a fundraising activity. But yes, if you're a public company, you can also do initial public offering. And nowadays, you have been we have been witnessing the grand success of IPOs like Zomato. We have got Nykaa IPO, which got I think 80 times subscribed by retail investor. Day before yesterday, they got listed also. We got IPO of Paytm, which also although got subscribed 2 times, but still this is the I think biggest IPO of any time within Indian territory. I think it has gone about 18,000 crore plus INR. And what is happening in IPOs? In IPOs, IPOs like Zomato, Nykaa, Paytm, etc., etc. Many of them are in pipeline. These IPO is basically a kind of hybrid version. So under that, few of the portion of the equity share being issued by the company, but a large chunk is being offered for sale. It's an offer for sale by the sitting investor to the investors. So let's say 100 crores IPO is being launched. Out of 100 crore, 30%, 30 crore must be a fresh issuance for which money being raised by the company, but 70 crores are nothing but an exit by the sitting investor. So money is not going into the company's kitty. Money is going to the investor's kitty who would have invested into Paytm, Nykaa, Zomato, and so on and so forth. We have companies like Ola, we have companies like Make My Trip, we have companies like Uber. So these all companies are waiting, for the IPOs. In fact, these were the companies who have been insisting the ministry to allow us to go and get our company listed abroad, direct listing overseas, because their demand is quite high. Under the Indian law, until the amendment to Section 23, under subsection 3, there was no provision which allowed you, for sort of direct listing. But now the government has allowed direct listing of Indian entity. Now company like Uber, company like Ola, they can go abroad and get the company listed in NASDAQ, in London Stock Exchange directly without being listed here. So that's allowed there. Although this section is there, but again, the relevant rule regulations have yet to be notified. And I think not only the companies there, but the relevant amendment to be taken place under the Income Tax Act, under the FEMA, FDI policy, under the relevant sectoral guidelines also. That's something I think which the government is working upon. But yes, that's there that there is an enabling provisions carved out for the companies to go and get the overseas listing done. Now, since I'm talking about IPO, let me also touch upon one relevant aspect which may be of interest to you, which is SPAC. You would have heard about the SPAC, Special Purpose Acquisition Company. So SPAC is again a sort of very sort of emerging concept globally. So globally, SPAC, SPAC, Special Purpose Acquisition Company, has been emerging as one of the most preferred structure to achieve the funding needs of any company vis-a-vis public access through listing. So what happens in SPAC? What happens in case of a SPAC listing? A special purpose acquisition company, we call it as SPAC, is created, incorporated, but that company does not have any business objective of its own. The whole object of this company is to acquire some operational company. We get a company incorporated with no object. That company is listed on the stock exchanges, and that company acquired some operating companies. And through how the funding happens, SPAC is something which is not allowed as of now, in India, but SPAC globally is a preferred way of raising funds, and we have seen company like Renew Power. Renew Power has got its overseas arm listed on NASDAQ, I think 2 months ago. And now the country like, NASDAQ, London, Singapore, they have allowed listing of the companies, and we have got the company listed there. Again, I think in India, SPAC has not yet allowed, on the Indian stock exchanges, and there are some sort of regulatory challenges. And I believe that, these are going to be sort of taken care of going forward. For example, what could be the potential reasons why the SPAC is not allowed, or what are the regulatory concerns? Let me tell you. As I said, SPAC is a company with no object. Under Indian Companies Act, you have to mandatorily provide the business object of a company. You cannot incorporate a company with no object. So So that's the one thing, how the regulator, let's say registrar of companies, is going to entertain the application for formation of a company with no business activity of its own. That's issue number one. Number two, let's say you have somehow you managed to get a company incorporated. Somehow we gave some justification, and to the best of justification, we got the company incorporated. Still, there's a risk of striking off, because let's say company got incorporated and company does not carry any activity for next 1 year or so. Under the provisions of section 248 subsection 2, ROC has a right to go ahead and get the company dissolved, struck off, because the company does not carry business operations. So unless and until you carry your operation business, unless and until you acquire the company within 1 year and start the operations, there is a risk of striking off under section 248. Same way, inability to meet the track record. As I say, spec is a list funding through a listed company which has no object. Our stock exchange requirements, SEBI regulations, NSE, BSC, internal guidelines, they may not allow a company with no track record for listing. You have to be a company with some sort of track record, then only will allow you to get the listed. So that's the reason, we have got some sort of regulatory challenges also SPAC. Now, there could be others also. For example, there could be a FEMA related round tripping issue. Now, for example, as I said, that Renew Power has got its foreign arm subsidiary listed there in Singapore, in NASDAQ. Now, what they have to do, this NASDAQ listed company SPAC, they have to acquire some operations, some entity, some operating company, right? And that company would be doing funding, raising the funds. So what can happen? Let's say if that Singapore NASDAQ listed Renew Power unit, they acquire some Indian entity, right? Means a non-resident entity acquiring an Indian entity, maybe by secondary purchase or by way of a merger, we call it outbound merger. There could be some implication under FEMA, because under FEMA there have been FAQ issued by RBI which deals with sort of kind of round tripping. We say that no resident can hold any investment in a non-resident if that non-resident indirectly or directly holds investment in a resident. So think about a situation, Renew India would have floated its subsidiary as Renew Power US, which got listed, means resident holding investment in non-resident, and now this non-resident SPAC entity acquiring Indian entity, valid acquisition, I am saying, secondary mode or maybe by way of merger, it may be regarded as a round tripping investment under that FAQ issued by RBI. Indian Renew Power, resident holding investment in non-resident, Renew US holding investment in another Indian leg. So that issue of round tripping is also there, which needs to be clarified by government, ministry, RBI going forward once we get this SPAC operational in India. So that's how it has to be a thought through process when we talk about the sort of implementation of SPAC. But nonetheless, I would say in spite of this, SPAC is one of the most preferred way of raising fund globally, and we have seen its kind of impact in India also. Now, I would say I will do a bit interplay between the right issue and the preferential issue or the private placement. When we say right issue under section 62 subsection 1 clause A, right issue basically means you are going ahead raising fund from your existing shareholders who are the equity shareholders by way of offering shares to them in their existing proportion. And the preferential issue or private placement is that you are disregarding your existing shareholder. In fact, you are bringing a new investor in and you are offering shares to him in preference to your sitting investor. So that's the basic criteria of right issue and the preferential issue. Now, what are the securities covered under right issue? Right issue that you are issuing shares to the existing equity shareholders. So when we say right issue, right issue can either be of equity share, it can be of preference shares, or it can be of any convertible securities. For example, debentures, CCD, OCD. So a company can very validly issue convertible preference shares, convertible debentures, in addition to equity shares to its shareholders by way of right issue. This is completely allowed, because at times we read the very literal aspect of section 62, which is equity share. It's not so. No, shares of any kind, including convertible instrument can be issued. Yes, if it is non-convertible, then you can't. And in fact, this is also supported by the SEBI regulations. SEBI ICDR regulations, they also allow right issue of convertible instrument, convertible securities. On the other side, preferential issue of private placement. Preferential issue talks about the issuance of shares, equity shares or convertible instrument. But private placement allows, issuance of securities of any kind. So if you talk about non-convertible instrument, section 62 may not have a role to play, but section 42 has a role to play because it's a security of any kind. Now, at times people ask me, sir, what is the difference between private placement and preferential issue? And I have devised a very, very plain, simplest meaning of private placement and preferential issue. And I think this is the best one to my understanding, based on my experience. See, we say private placement, meaning thereby I am a company with about 20 shareholders. Private placement, as the name suggests, I am placing the securities privately to a new person. I am placing my securities privately to a new investor, or I am introducing an investor privately to my company. That's a private placement. So as and when securities are being placed before a new investor or a new investor is introduced to the company by way of private placement, it is a private placement. What about preferential issue? Preferential issue basically means I am giving preference to my over my existing shareholders, or I am not treating them equally, meaning thereby either I am giving, either I am making a issuance of security to a new person in preference to my existing, or I am issuing shares to few of my existing shareholders. I am giving preference to 3 over 17. That's a preferential issue. So meaning thereby in private placement, now this is the crux. In private placement, there will always be a preference to my existing shareholders because a new investor being introduced, obviously he's getting preference. And in preferential issue, may not be a new investor, but there will always be a preference. So private placement will invariably involve preferential issue. The moment I place a new investor, it means that I am giving preference to a new person over my existing shareholder. So every private placement is a preferential issue, not vice versa. So the crux basically is that every private placement has to be regarded as a preferential issue, not vice versa. Because in private placement, I'm introducing a new person. The moment a new person or an investor being introduced, he is getting preference over the existing shareholders. That's how it would also be regarded as a preferential issue. Now, in right issue also, there have been some sort of situations I have been confronted with. Probably you guys may also, what also happens at times when you raise fund, you are representing a company or the investor, there is some amount of loan sitting in the balance sheet. And the loan is from the promoter or investor. Now how to deal with that loan? You do one thing, because whenever you do an investment, generally investor does not like any unforeseen liability or any contagious, liability. They say, clean that loan. I'm not comfortable with that loan. Tomorrow, this loan holder should not come to the company. I'm the holder. They will say, pay my loan back. And this is the amount of interest, 8%, 10%, compounded interest, 60%, 18%. I'm not comfortable. Take that loan out. Now, how to take that loan out? You have to basically sort of repay that loan, but the company does not have money. How to go? Either I have to borrow new money, then, pay that money, but again, the new money will become a loan. How to go about? Better way of doing is that you convert that loan into equity. Even if you can't do that amount of loan conversion into equity by way of preferential issue, validly, legally, you have a right to convert that loan into equity by way of a right issue. So that's something which is doable, because conversion of loan into equity is nothing for, it's not in kind. It is basically conversion of cash into cash. Let's see, if I have a loan amount 100 rupees and I have to repay it to a third party, and I say I need business need, I will raise money from the investor, from my shareholder by way of right issue. Money will come, and that money will come into my this pocket, and from this will go to this pocket. loan will be out. So can't I do exchange directly? I can do exchange directly. I will raise, offer letter to my shareholder saying this is the right issue offer I am issuing to you. In consideration, don't pay money. Your loan is being adjusted against it, and I'm converting your loan into equity. As against your loan, you will be holding these much of equity shares going forward. But yes, it has to be properly documented. You have to do necessary valuation, not from the company law perspective, but maybe from income tax perspective. Take care of those governance and the relevant formality. But that loan can very much be converted into equity by way of a right issue. That's something which is doable. Now, right to renounce to a third party. This is very critical point. This is very critical from the business perspective. And I experience been 99%. I think people have disregarded it. They have been copying it and pasting it, which probably is not a preferred way of looking at. See, law says that under section 62, law says that right issue. When I make a right issue to my shareholder have two options actually. Either three options actually. Either they can subscribe to my right shares, or they may reject it. They will say, okay, I'm subscribing, or I'm rejecting, I'm not. Third is that they have a right to renounce it in favor of a third person. So if I am the, let's say, company, I have issued, kind of right offer to, let's say, Mr. Puneet Agarwal holding 30% share. I'm saying, Mr. Puneet Agarwal, you're holding 30% equity share. Here is the right offer to you. You may subscribe, and you have a right to renounce it. And Mr. Puneet Agarwal is saying, okay, I'm not subscribing. I'm running out of money, or I'm not interested. What I'm doing, I am making a sort of renouncement this right in favor of Kiran. Now, Kiran on basis this invitation, Kiran can go ahead and get the share subscribed. And obviously, once I get a communication from Mr. Puneet Agarwal, and Kiran has shown her acceptance, I as a company have to make allotment of security to Kiran as a shareholder, and she will become a shareholder of the company. But the whole structure of right to renounce is subject to the provisions of article. It's a very powerful wording written under section 62. They say that right to renounce in favor of third person unless article otherwise provide. Meaning thereby, as a company, I will be well within my legal right to restrict Mr. Puneet Agarwal if I put in the article that no shareholder would have a right to renounce the right offer if being made in favor of third person. And I always take care of this thing. I think that's a critical area we should be very focused about. Why? Let's say today I am offering share to my existing shareholder, bona fide shareholder, but he is doing a renouncement in favor of third person. But that third person happens to be my competitor. So that competitor would get, a sizable stake, that too at a reduced rate in my company, which may not hold good, from the business operation perspective. So I think from the business, to protect the interest of the business, you can very well, and you should ideally, in my view, write in your article saying that right issue, if will be made to the shareholders, can either be subscribed by the equity shareholders on their own, or they can reject it. No right to further announce in favor of third person. That we may not allow, because as a fiduciary position of director, we think that if you allow it, it may have endanger vis-a-vis the company's business operations, qua the the kind of competitor who may otherwise get the benefit of having shares in the company allotted on right issue basis. That's very important. I think you should be mindful about it. Now, one of the relevant aspect again, which I have been invariably sort of coming across, is that pricing. Pricing is a very important aspect, particularly in case of a preferential issue. So if you issue preference shares, when you issue shares on preferential basis, there is a requirement under rule number 13, sub rule number 2 of SEBI of share capital rules. They say that if you issue any security which is convertible into equity, you have to give the price of that security, or the conversion price actually, at what price that security would get converted. Now think about a situation, you are issuing CCD, compulsory convertible debentures, or CCPS, compulsory convertible preference shares, maybe 5 years down the line. Law requires you to give exact conversion price upfront, or 6 months prior to conversion basis of a registered value report. But it may not be that easy. It may not be feasible to get the exact sort of conversion price. In fact, to the contrary of this rule, under FEMA, when we issue this instrument of this nature, like CCD, CCPS to a non-resident, FEMA allows you to give a kind of conversion formula. Rather than conversion price, you can say that the conversion price would be arrived at by way of calculation as per the formula given here in below. So that formula is basically worked out, calculated basis the company's relevant credentials aspect, including but not limited to the turnover, profitability, etc., etc. The kind of business, the kind of dynamism we are living in, the kind of business we are, that we are, at tech companies, startup companies, business are so dynamic in it may not be that feasible to give a kind of exact conversion price. It has to be worked out on some formula. So FEMA allows you, but company law may not allow you. So the idea, again, a best practical situation which I can follow is that you may not give an exact conversion price, but certainly you can give some sort of range. You can say that the conversion price would range from X to 20%, which is based on the computation as per the following formula. So please take care of this rather than giving an exact formula, which may lead you to non-compliance of rule number 13.2. But at the same time, you may not be in a position to give the conversion price. So do some sort of hybrid and bring your kind of bona fide efforts in this regard and give that conversion price range of that conversion price basis that formula. So that's I think again sort of issue which I have been facing vis-a-vis instrument being issued by the company primarily to non-resident. But again, as I said, issuance would invariably involve Companies Act, because company law has to be followed. It's a mother law which you have to follow. Invariably, you have to follow the company law, irrespective who is the investor, whether the company is a listed company, unlisted company, private company. You have to follow that. Okay, Kiran, just to know any questions, anything anyone would like to ask, would be happy to.
One question is there, sir. Mr. Saurabh Agarwal has asked that as the deposit rule says that any amount received by a company from any other company, I think he's saying this is an exception. So a company can issue debenture to another company which are neither secured nor listed without complying the provision of deposit.
Yeah, I absolutely. I think I should have touched upon it. I am not. You're right. So again, it's a kind of diversity of view within the market. So the way I read deposit rules, deposit says that deposit, as I said, deposit is inclusive. Everything is deposit except exhaustive list. Now, when we talk about the excluded exhaustive list, there is a general clause. Let's say company to company transaction. Not only that, I would say, Saurabh, there is also a clause which says that issuance of securities, debenture may also fall there. So other than this general exemptions of company to company transaction, there is one more exemption. A company can raise money by way of issuance of securities, provided that the allotment is done within 16 days. So one can also take a view that debenture is security. So issuance of security by way of within 60 days allotment, it's not a deposit. Second view, one can take company to company transactions. I am issuing debenture to another company. It's a company to company transaction. Purely, it's not deposit. So view. But my point is that in general category, within the general 18 exemption, there is a specific exemptions carved out for debentures, and that too got amended twice, as I said. Earlier, it used to be, debentures convertible within 5 years or optionally convertible, something like this. Then they also excluded, kind of unsecured but listed debentures. So my point was that, within the specific 18 exempted category, there are two general, which we mentioned. You mentioned one, company to company. I mentioned one, securities issuance. But there is a special one which deals with, debenture. So my view is that, and my suggestion would be, depending upon factor, importantly the kind of transactions, volume of transactions, one should take a safer, one should be conservative in treating that debentures, and I think that would be an aggressive view, that company to company or whatever say company security issuance. Otherwise, this exemptions under item number 9 vis-a-vis debentures may not serve any purpose. That's my view about it. Having said so, people would have taken a view. Again, I can't fight with anyone. Views are views. If someone can support his view, her view, well enough. But I think that specific clause may lose its purpose if I go by the general view. That's my sense about it.
Thank you, sir. Thank you. So one more question I wanted to ask. Sir, please also give us a brief. Sorry.
Two questions actually.
Okay. We also wanted to know, sir, please brief us about how to choose between different securities options available. What should we keep in mind while choosing which option is best for our fundraising requirement? Like we should go for debentures or convertible debenture, or non-convertible debenture, preference shares. How to choose between all these? More of planning.
So again, Kiran, no, I absolutely agree with, but point is that it's not your choice. It's not only your choice, it's the choice of the investor also. You have to, it's a mutual discussion, deliberation. I want to issue equity, but my investor not comfortable. So it has to be mutually discussed, deliberated. Let's say I want equity. Okay, let's discuss it. I want equity issuance. Why? Because if equity I issue, there is a positive side that I am not supposed to make any payment like that of interest on debentures or dividend on preference shares. That's a positive side. But negative side is that I am losing control, because that equity shareholder will come, they will hold 15%, they have a right to vote, and they may also drag me to court of law in case of NCLT proceedings under operation mismanagement, because they have more than 10%, right? So it's a mutual choice. Same way from the investor perspective, they may decide to go for equity, they may not. Let's say they go for the preference shares, because good part about preference shares is that they will get a return and they will time to analyze the risk of the company. The company is free or the risk is assessed fairly down the line. They may go and get the company converted into equity. They will become equity shareholder. But till then, there is a risk that they cannot take any case against the company under NCLT. They have no voting power in general. You got it? So that's the point. We have it. I don't know whether you guys recalled or not. Geo Reliance, subsidiary company. You guys would have seen. During the course of, and Geo is a classic example, I think one should look at, during the course of this Corona call, Geo raised close to about 2 lakh crores by way of different private placement issuance. And, first time probably I would have seen the investor like Facebook and Google. Facebook and Google both are competitor, but both did investment in Geo during last 1 year. Facebook holds about good percentage 9.98%, and Google is holding about 4.45% in Geo platform. Together both are competitor, but see the percentage. None of these investors who are not related to each other were allotted 10% or more, just because of this aspect of NCLT. The biggest investor being Facebook, who holds about 9.83 or 9.93%. They allotted 9.93, below 10%. And I'm sure the idea would have been to get out of 10% threshold, so that there should not be any unnecessary, circumstances, raising a concern before the court for no reason, So that would have been the idea. So again, as I said, it has to be mutually discussed, deliberated. Now, I also give you a classic example. I think I forgot to discuss with you when we discussed about the equity preference. I forgot to mention about the differential voting right. It's a very classic instrument. Why not DVR? Differential voting right, which basically shares with the DVR, differential voting right. We call it DVR. They are the equity shares, but with differential voting right. It again is a very relevant instrument, at least for those who want to get control in the company.
हरीश जी, आपके एंड पे थोड़ा सा वो हो गया है, क्रैक हो गया है.
Yes, sir. There was some network issue, Harish sir.
Yeah, I could see. I was not able to see myself actually. Am I audible?
Ah, yes.
So the differential voting right is an instrument which was devised again. The differential voting right came into effect via the Companies Amendment 2000, via Section 86 of the 56 Act. It has been there for last about 20 years. So the idea of DVR was that, as a promoter of a startup, you keep issuing shares to the investor. But what happens, like this has happened, live case study of Make My Trip. Deep Kalra, who started the company Make My Trip, as on date, he holds merely about 5-6%. He's still founder, CEO, but he has only 5% share in the company. Rest being held by the investors at large. Now, he had it been a case, he would have applied, differential DVR. So what happens in DVR? The very mechanism of DVR is that you are an investor, you want to put in money and hence get the handsome return. What I'll do, as against one share, I will give you 1000% preference dividend. I will get only 100%, you will get 10 times more, 1000% dividend, higher dividend. But at the same time, I will reduce your voting power. For one share, you will get 0.001% voting, but for one share, you'll get 2000, 3000% dividend. So idea is that to give you more power in terms of revenue, money, but to keep control voting with me only, being the founder, because I will run the company. So DVR again can be a classic example. If you ask me, if I would have been in a situation of a founder of, startup entity, probably I would have preferred, DVR, provided again, I am in a position to meet out the expectations of the investors in terms of his commercial, wisdom, commercial, objectives. So as I said, this is mutually agreed upon, kind of mutually sort of discussed, deliberated, agreed terms and conditions we have to arrive at as instrument.
Harish ji, the example that you gave, I think that was only an example. Once it is DVR, whatever can be the arrangement, because after all, even issuance of shares would be a subject matter of agreement only. Is it correct?
Certainly. So DVR, see, idea is that
to be precise, before you answer it, to be precise, you gave an example of differential dividend also. But it may be that we can issue shares without differential dividend. We say that these are differential voting rights and the price is different.
No. What I'm saying, see, there could be only two kind of shares, either equity or preference. Within the equity, you have to issue equity shares with normal right or equity share with differential voting right. So when we say equity share with differential voting right, means equity which has a differential voting or dividend.
So that's what I'm saying. So let me give you an example. Yeah. Let's say that there are two people who come together to do business. One is more of an investor, second is more of a executor. Yeah. Now we all understand this. That's the example that you also gave. Now this investor says, all right, I am putting 75% of the money, you have put only 25% of the money. But to be fair to you, because you have put up this company, but for your efforts, this company could not have been even made operational, leave aside being profitable. Yeah. I want to give you differential voting rights. So there is a class A share and there is a class B share. In one case, the voting right is, let's say, 1:1, and in the other case, it is 1:3.
Yeah.
That is doable. There's no difficulty.
Yeah. Doable. What I'm only saying that if voting power is voting rights, voting power is higher, dividend has to be lower. You can't say that higher voting right with equal dividend. There has to be a difference.
So that goes without saying, because if his capital is 25%, dividend will be only 25%.
Generally,
the other person's capital is, let's assume that the dividend is pro rata to the capital invested. So in my example, 25% was Mr. Doing promoter and Mr. Financing promoter was 75%. So dividend goes in the same ratio of capital contribution, but the voting rights are going in a different way, that Mr. Doing promoter gets 3 times the voting rights. Is fine?
No, that's what I'm saying. See, normal balance, it would have been 25% dividend, 25% voting. Right? 25% voting and dividend and 75% voting and dividend. Now what you are doing, you are saying dividend would remain intact, voting would get altered. I'm saying, please
Yes.
alter this. I'm saying.
That's right. That's right.
Yeah.
Correct. Understood.
You have, if you are increasing the voting, please dilute the dividend also, which you are not doing in this case.
Is it necessary?
I feel so. I have not come across a single precedent, in fact, because see, otherwise it would have a normal case. It's happening by implication. But you have to, if you are saying that I'm giving a higher amount of voting, you have to also reduce his dividend.
No, that's what I'm saying. This is a typical situation where one person is doing the job. So dividend, they don't want to change. They only say that since you are doing and I want to make you equal partner in decision making.
Yeah.
It can also be situation. And if I am not wrong, then Companies Act do not as such define that this would be the only contour of that differential. There is no contour defined.
May not disagree with you, Puneet Agarwalji. I may not disagree with you, but I feel that when you doing some sort of alteration vis-a-vis the voting and keeping the dividend intact, in my view, you should do something with dividend as well. Otherwise, it would have a normal class of equity shares. That's my view as of date. In fact, people have also asked me, sir, the differential can also be nil. Can you? It's also an interesting query which I have been posed in past. Can you issue voting power with nil vote? I'm saying you have 1000% dividend, but nil voting power. So one can argue that differential may include nil also.
No, the only problem with this argument would be that you cannot make something which by definition it cannot hold. So you cannot say that an elephant by definition to be a lion. That I think equity by definition would always have voting right.
Exactly.
So of course these are all pure questions of law and have to be determined in appropriate cases. But ingenious lawyers like you never allow these matters to go to the courts. You would ensure that it never goes to the court.
Sir, I have kept thing. I think I should show it to you. And this is my. It's a maybe a satire, but a realistic thing. And I also keep this with me, and I'm going to show it to you guys. I don't know which you guys you may appreciate or not. You know, when people keep asking, my client keep asking me, I keep giving a solution. I keep giving solution, maybe solution A, solution B, solution C. I always feel that there is a solution, not A but B. And I always think out of box, but not out of law. But at times, you know, I get confronted with query B, C, D, E. Then I have nothing but this to show. Please see. Can you read it? Kiran, can you read it? What is this?
I can read it. I am a lawyer, not a magician.
In fact, it should be the other way around. I am a magician. I only pretend to be a lawyer.
So this I always keep with me since beginning. I'm saying, you know, I can help you to some extent. Otherwise, I can't do sort of thing which probably I may not justify myself. So I am a lawyer, may not be a magician. You may have to visit.
One more thing, you have raised a very interesting issue of this aspect. Look at the differential voting rights. There are few companies which actually have these DVRs. If I'm not wrong, there is a company called Jan Irrigation which has this DVRs. There's another company. I think Tata Motors also has DVRs.
Tata Motors and Pantaloon. These two, Tata Motors, Pantaloon, they did DVR issuance initially around 2000. Then this got sort of barred, prohibited because of SEBI regulations. SEBI came out with the amendment saying no listed company can issue superior right. That's how no one could have issued post Tata Motors and Pantaloon. But again, now very recently, SEBI has made some amendment and they are allowing the rights, shares with superior rights being issued.
So even Jan Irrigation has that. But what I have seen is that their valuation of these shares. So one day one can move in a different direction, another can move in a different. How do you really value these? Is there any concept of valuation around these?
No, so see again, this probably is a better you guys may talk about valuation. You know, probably this is the area of expert like you guys. I never touch upon the valuation, which is not my domain. Even I tell you, not me, even the court in various judgments say that we will never go into the commercial wisdom of the board of directors or the external people like valuer. It's their commercial wisdom. If the law is complied, there's a fair disclosure compliance. I don't think we have a role to play further going into the detail. So if you ask me to talk about valuation and things, I don't think I would do justice by making any comment on that. And stock exchange, you know, sir, this happens, just happen. I don't know how it works. You're on mute, I think.
This actually is a very interesting field.
It is. So investment, merchant banking, you know, investment side, it is no doubt about it, you know, interesting, dynamic one. But again, one has to give time, one has to be focused. Unfortunately, not my area of working. I am happy, so to say, with my
No,
existing.
actually, I think that would have been the basic reason why SEBI would have said that you cannot issue these differential rights. Yeah, because that kind of a situation, it's very difficult to fathom that what is the, from a commercial standpoint, what would be the differential of this value and what will be the effect thereof.
And in fact, okay, one more mode of funding, one more instrument which one could have used, and I have done this twice. Okay, let me also share with you guys. We call it a treasury stock. I don't know if you guys would have heard about treasury stock. It's an interesting instrument. Treasury stock is an instrument which is not defined under the Companies Act until 2013. Not defined even, it never got defined as on date, but it got referred first time. So treasury stock is a treasury means what? It's your own treasury. We call it khajana. So treasury stock is a US concept. So what happens in US? In US, a company is allowed to issue shares in its treasury. So we have issued the share capital, but that issued capital is still within the treasury of the company. Let's say 20% extra shares we issued, but there is no identified investor. So shares have been issued with no identified investor. As and when company needs money, investor comes, he gets the relevant shares and money comes into the company's kitty. So shares have already been issued and we keep allotting it to the investors as and when we get an investor, we needs money. That's called treasury stock in the US concept. In India, there is no definition even as on date of treasury stock. So what actually happened, under the scheme of arrangement and buyback, particularly scheme of arrangement of buyback, what happens whenever we merge a subsidiary company, and it's a very interesting thing I'm telling you. There are 6 instances wherein company have done. I am part of 2 transactions, by the way, and I can share the name also because it's in public domain. When a subsidiary company being merged into a holding company, let's say a company in which holding company holds about 80%, subsidiary company being merged into holding company through a court scheme. So 80% stake of holding company to subsidiary would get cancelled, extinguished pursuant to amalgamation. So rest 20% shareholder will get shares in the holding company, right? What happens in treasury stock? The holding company prior to a scheme of merger transfers that 80% stake in the subsidiary to a trust, independent trust that has an independent trustee. So typically upon the merger of subsidiary company, that 80% does not get cancelled. That against 80%, the trust gets shares in the holding company. And the beneficiary of 80% is who? Holding company itself. So technically a company, and think about if this holding company is a listed company, because we have cases of listed company, a listed company pursuant to merger of its subsidiary company into listed company is holding about 80%, shares issued to that trust in the listed company and the beneficiary listed company. And what typically happens, the listed company keeps issuing that shares through trustee from time to time in the open market as and when they need money. We have classic example of Reliance Petroleum, Mahindra and Mahindra, Jayaprakash Associates, Jayaprakash Power, Spice Mobile, and one more. We have 6-7 classes wherein the treasury stock were allowed to be created, and still that treasury stock is lying in the balance sheet of the company. It is there in the shareholding pattern of the company, which is under the custody of the trustee, and the companies are using it as a fundraising mechanic from time to time. Now, what happened actually under the new Companies Act under Section 233, if I'm not wrong, under subclause 2, clause H, they have sort of given a restriction saying that now going forward, pursuant to the amalgamation, no company shall create and hold any treasury stock. So that has been banned. See, the term which was never defined has been referred for the first time under the new Companies Act. And I tell you why they have prohibited that creation and holding of treasury stock. The problem with treasury stock is the governance issue. 2 governance issue. Number 1, the treasury shares which are under the custody of a trustee, the beneficiary being the company only. So there is always a demand from the regulator side that it should be shown as a kind of promoter holding, because they may vote in consultation, in concert with the promoter of the company. The voting in respect of that treasury may be 6% to 10%, 12%, which is a sizable voting in a listed company, may decide the passing of a resolution. So make it a public promoter holding rather than the public holding, to which the trustee have their own concern. No, we will not. Why? Because we are independent trustee, independent director. Promoter have no role to play. The second issue with that treasury stock is the computation of EPS. When you compute EPS, you divide the profit by the number of outstanding equity shares. The regulator is of the view that because treasury stock is a share, in which you yourself is the company itself is a beneficiary. When you put in the denominator the number of equity shares, you have to take that out, that what we call the treasury shares. So because of EPS and the governance disclosure perspective, that creation and holding of the treasury stock got banned under the Companies Act 13, which never got defined. But yes, we have got 6-7 classes of cases of treasury stock in past. Now coming to some more nuances of the equity shares and the preference shares, because I am just thinking to put for your consideration the more case studies which may be of help to you guys. Process I can read out, but which may not serve the real purpose here. Preference shares, again, the preference shares is an instrument which does not carry right to vote, right? But now what they have done, and which used to the case also under section 87 of the 56 Act, now under section 47, they say that if there's a default in terms of payment of dividend to preference shareholders and the default lasts for at least 2 years, then the preference share would have right to vote on all resolutions, every resolution which would have put before the equity shareholders. We call it defaulted preference shares. So that actually becomes a case of concern for the companies. Generally, in the infrastructure company, importantly in power sector company, the funding happens through issuance of the preference shares, optionally convertible preference shares, and these generally are the related party transactions, group level entities. And obviously, because of the fact that the gestation period for a power sector to generate profit generally is about 4 to 6 years. I would say 5 years generally. And in the absence of any profit, how to make the payment of dividend? We can't make. So one plea can be taken by the company, which they do take that. We do not have the profit. So if we do not have the profit, we have not declared the dividend. There is no dividend declaration, then there is no dividend payments. Accordingly, section 47, right to vote may not apply. Again, in my view, that may be an aggressive approach, because the law has made it very clear. If you have not made the payment of dividend, there is a default for 2 years. So again, maybe as an ideal approach solution to this would be, you may have to seek a kind of waiver. You may have to seek a waiver sort of, from the preference shareholder, saying that, stipulating that, whatever amount is due and liable to be paid to us by way of being preference shareholder, we give its complete waiver. We company does not owe any money to us for the year ended so and so on account of payment declaration of the dividend. So that's something, you can consider to undertake. Otherwise, I think, regulator may trigger the requirement of 47, saying that he has a right to vote, and probably this would have not been voted upon by the preference shareholders. So that's something which I think you may come across when you do the implementations after raising funds in a company via preference shareholders, that too in case you do not have proper liquidity. In private placement also, I have been coming across a number of times the requirement of making a private placement offer. Typically what happens in a company nowadays, we are issuing shares to different investors in tranches, or maybe what we are doing, we are issuing shares to one investor, which is equity shares, and shares to investor B, which is CCPS, and shares to investor C, which is CCD. Now, what law says that you cannot make a private placement of securities of any private placement unless the previous private placement has been abandoned or the allotment is complete. So if I have made private placement offer issued to company A for preference shares, we have to wait for completion of private placement A. Allotment has to be completed. Unless and until the allotment is complete, I can't make new sort of private placement offer to company B. So that's the requirement of law. Unfortunate, but the requirement is there only, right? So, but at times, but we feel we need to have the funding from the company B also. We have to raise fund from 3 persons together. What to do, how to go about it. So again, the solution, maybe the solution-oriented approach, maybe you may do a kind of deliberation discussion with all the 3 or 4 investors. While laws requires you or restrict you from opening second offer while the first is open, law does not require or restrict you from opening 2, 3, 4, 5, or 6 private placement offers simultaneously. So you can open these private placement offer, which are 2, 3, or 4 simultaneously at one time, and close it on the same day. So that's something which is not prohibited under law. So that's, again, it's a matter of negotiation, discussion, deliberation. Probably you may find it out feasible vis-a-vis raising of your fund. Kiran, any further questions, query?
No, sir. Thank you, sir. Thank you. Vipin, sir. Puneet ji, are you there? Puneet, sir? Okay. Thank you so much, Harish sir, for such nice deliberation on the topic. It is always good to hear you.
No, I would have actually loved to entertain more query, and I really cherished the kind of participation Puneet ji has had. I don't know if he's still continuing or okay, he's still. So I would have loved to have. That's the kind of deliberation, kind of discussion. I really cherish having it, and completely my pleasure having people like Puneet, you, and other here. But I wish, and I'm here. If you can ask, and probably I would have so many things. I was just thinking and which section to pick it, and I don't want to discuss something which is very procedural, which is known to everyone here. I think people are more brighter and sharper than me, but I really want to share to and from between us. So if I can be of any further help to deliberate upon any query concern, probably I would also learn out of this sort of dialogue or interaction.
हरीश जी, एक इंडियन कंपनीज के दिमाग में जो बढ़ रही है, हमेशा एक क्वेश्चन जरूर रहता है कि हमारे को सस्ती फंडिंग कहाँ से मिल सकती है. वैसे ही क्वेश्चन अब कम हो गया जब से बैंक्स के रेट कुछ कम हुए हैं, बट क्या फॉरेन फंडिंग कुछ, इज इट रियली चीपर?
Yes, sir. Foreign funding में FCCB सब for on, and this has been the case from day one. Very recently, again, I have to cite Deep Karara, Make My Trip. You won't believe, 2 months ago, they have raised a fund about 2,000 crore, that too at, I think, 0.5 or 1% of interest. And the money lying is in Mauritius, which they would be remitted to Indian operations. So foreign currency convertible road, generally you get a money if you are a company of repute, good corporate governance, compliance, good rating, you may get good amount of funding raised, anything, even at nil rate of interest, by the way. From nil to maybe 0.5, 1% of interest, you can get the funding. And you have two options. That money holder, that bond holder may either get the money converted, bond converted into equity, or they may get the money repaid in due course, 3 years, 5 years down the line. But yes, raising money from abroad is cheaper.
And what is the transaction cost for that?
Sorry, sir?
What is the transaction cost for that?
See, again, you have to have a different consultation with a different stakeholder. You have your international merchant banker, lawyers of foreign jurisdiction, brokers, road shows, Indian lawyers, Indian bankers, 6, 7 underwriters. So 5, 6 intermediary would be there. It could range, maybe some percentage of the amount you are raising. It may vary from, let's say, 2 to 5% of the total money you are raising. In terms of high level, I'm giving you the estimate.
And companies with what kind of minimum requirements can do this? What are the minimum, let's say, 3 points which are absolutely essential for raising FCCBs?
So listed companies, generally, yes, provided, as I said, they have,
no, unlisted space. Listed, they know all options of fundraising. In unlisted space.
So, and again, a good track record for last 3 years, this is the must. No sort of, non-compliance, governance, no qualifications, something like, I think this should work.
Even smaller companies.
Not a floated company, newly floated company, it should have a sizable operations, it should have a sizable turnover, it should have been operation for last 5 years, track profitable record and all those things.
So sizable means, can you put some number to it?
But to the extent I recall, again, because I'm talking about FCCBs has been the window which was open to unlisted company for some time. I think for 6 months, something like this. I don't think as on date it is open to an unlisted company. I don't think so. It is open. Raising fund via FCCBs, I don't think it is open to unlisted company. And here also, when I said that Make My Trip, not Indian entity, Make My Trip Mauritius, they raised the fund, and which money will go to India only eventually to a subsidiary company. So what they did, there's a scheme, foreign currency convertible schemes, 1993, which got relaxed, I think 3 years ago, and they opened the window for the unlisted company, I think for 6 months. I don't think that window is still open, but yes, that was kept open for 6 months.
So for unlisted companies to raise debt in foreign exchange, it's not possible?
No, I'm not saying so. That could be by way of ECB also, external commercial borrowings, completely allowed. So here I'm talking about the FCCB convertible, instrument. ECB, you can raise it. So you have to go and speak with the kind of foreign lender, foreign institutional investors. They can raise it, they can lend it to you, and it has to be subject to compliance of ECB rules, under FEMA.
And what are the typical rates for that lending?
Again, would be cheaper than the Indian law. Would be cheaper than the Indian law, and they are the requirement that track 1, track 2, track 3. There is a minimum maturity period. You have to have this money with you for at least minimum 3 years, 5 years, 8 years. They are requirement who can be the potential lender. These are requirement of end use. You have to use this money for these end purposes, and it has to be reported with the RBI on monthly return, and also you have to get some registration initially. So there is no restriction, sort of restriction as such. But yes,
so a mid-sized company having a turnover of 500 crore rupees, good track record, 10, 12 years.
Certainly you can.
You can.
Certainly you can.
And here again, the expense 2 to 5% types within that bracket?
Yes. As I said, you have to comply with the minimum maturity requirement, which generally vary from 3 to 5 years. Before that, you can't, repay. Obviously, this is to take care of the interest of India, foreign exchange currency. We got the Forex. Forex has to be in India for at least 3 years. This should not go out, immediately. That's the whole idea.
But with the money becoming so cheap in India, would this have any further, is it going to continue to have relevance?
Which one?
The borrowings from abroad.
Why not?
Because I'm saying because Indian money is also getting very cheap now. I think good corporates are getting money at 5-6% in India.
May not be all. Actually, there are so many covenant also they are putting in. That's also the thing. I think a lot of covenant condition they are putting in the bankers also, in the lending document also, facility agreement also. Let's say I am advising a client, we have got the funding, through overseas, and collateral we have put the pledge and all those things. Through the pledge of shares, we have been in a position to get the funding done from the overseas bankers, right? Which may not be that easy, in terms of security. Our Indian banker may be more demanding. Not only pledge, in addition to that, you also create some security, some asset. You have to create a charge and all those things. So in that way, they moderate.
That's right.
So interest.
And if the Indian story goes well, namely that Indian currency appreciates, then I think this would be a win-win situation.
Hopefully, yes. Hopefully, yes.
Kiranji, I think it is 5:45.
Sorry, sir?
No.
48, sir. I told you, sir has... he's a very good speaker. He always wants to answer as many questions as possible.
I think Harish ji has spoken from his heart.
In more ways.
Yes. Fully appreciated. And it was really a very, very, I would say, a session which, as you rightly stated, not on procedures, but on the substantive part of it, with lots of experience along with the information. So I think it was a real great learning. I was hooked this entire session.
Pleasure completely mine, and it would have been more sort of extensive, and that's what I was discussing with Kiran the other day. Let's have some 3 days, 4 days extensive workshop for 4 hours each. I'm not boasting upon, but you won't believe there was a time wherein I would have, and this credit goes to my audience, complete my audience. I would have taken about 4 hours in discussing, deliberating 2 sections of company law. We took about 4 hours at complete deliberation discussion, no nonsense, complete discussions on the practical, logical aspect, nuances of these 2 sections. I may not be in a position to quote those sections, may not make a sense, but yes, one section was that of fundraising and one was of corporate restructuring. We took 4 hours to deliberate that section. So I think
you referred to also that if we discuss about the practical aspects of it, it will take some time. I think we can, Kiranji would, in discussion with you, be able to create some program, and we would be very happy to have you in that program. So we would look forward to more and more such seminars with you. Harish ji.
Certainly,
Correct,
sir.
because fundraising is really very important. Although there are so many hurdles an entrepreneur face while starting any business or while doing any business, but funds are very crucial because without without the funds, you cannot move forward. So we'll
It's part of,
definitely. Sorry, sir.
it's company's heart, actually.
Yeah, it's company's heart. Definitely, sir.
Many of us also call it love, live blood.
Life.
Live blood.
Live.
I agree.
Thank you, sir. Thank you so much, Harish sir. Thank you so much, Puneet sir. Thank you for such a wonderful session on the topic. And anything you want to say, Puneet ji?
No, Kiran ji, I request you to kindly give a formal vote of thanks so that we can close.
Thank you. Thank you. Thank you, Harish sir. Thank you very much for the session. We'll
And thank
invite
you to all those who joined in the program.
Correct.
Without you, the program can never be successful. Thanks to all the audience. Thank you, ji. Namaskar.
Thank you, sir.
Pleasure.